Rule 701 provides an incredibly useful exemption from registration requirements under the Securities Act for companies that are still privately held and are not Exchange Act reporting companies to issue stock-based compensation to directors, employees, consultants, and advisors. One of these issuers can rely on Rule 701 to issue stock-based compensation. However, in any 12-month period of time, the issuer has to limit the securities issued in reliance on 701 to not more than the greatest of $1 million, 15% of total assets, or 15% of the class of securities. In every case, the issuer has to deliver to holders the written plan or contract pursuant to which the stock-based compensation is issued. There's also an additional disclosure threshold. If an issuer has issued greater than $5 million in reliance on 701 in any 12-month period of time, it was required to deliver additional disclosures to the recipients. Recent legislation required that the SEC amend that $5 million threshold and raise the threshold, triggering additional disclosures to $10 million. That amendment to Rule 701 was approved by the SEC in July of 2018. At the same time, the SEC issued a concept release soliciting comment from the public regarding Rule 701 and whether certain features of Rule 701 had become outdated or needed to be revised, given that many private companies are staying private longer and that a lot of the features of the gig economy are not well addressed by the existing parameters of Rule 701. The concept release also requests comments regarding Form S8, which is the form of registration statement used in order to register the resale of securities received as stock-based comp. Rule 701 also contains an integration safe harbor. This means that companies that are relying on 701 for their stock-based compensation issuances can have legal certainty that other transactions that they undertake in close proximity to their 701 issuances will not be integrated. The securities that are sold pursuant to 701 are considered restricted securities, but they can be resold 90 days after an IPO by non-affiliates.